right, joining me live now in the studio is Karl Means, attorney at Shulman Rogers, to talk really about this lawsuit between Google and Apple. And you did a great job of explaining it just a few moments ago. Perhaps you can help us with this.
The lawsuit really didn't start out between Apple and Google. It started out between Apple and Motorola. Motorola actually sued Apple to begin with, and then Apple brought counterclaims against Motorola, and then it gets all tangled up. In the end, the judge threw out many of Motorola's claims, left some of Apple's in place, and has come to the decision that it's all going to get basically washed away because they can't prove that anybody was even damaged by any of this.
So, in summary, Google sues Apple, Apple sues Google back, the judge makes their decision. This case remains ongoing because it's more than just about one patent.
Well, it remains ongoing, but the judge has indicated that he's inclined basically to just cut the whole thing off.
I mean, we talked about this earlier. This is a strategic move by really both companies. And let me ask you this, as someone who watches a lot of companies go through this process, does this process work of trying to fend off your competition by suing them?
It does in some cases, and it doesn't in others. And I think this is going to be a case where it doesn't really work very well. Both of these companies are entrenched in the market, and if the judge was to prohibit either of these companies from selling their product, it would have an enormous economic effect, and the judge simply isn't going to allow that.
Well, you know, when you look at these cases and you see company A versus company B a lot of times, is it ultimately about how good the lawyers are, or is it about really the content of these cases? Because whenever we look through them, we of course see the press reports and the press releases, and you don't ever see the details of the cases. Which one is it usually that becomes the winner? Is it basically a media war?
It's not necessarily a media war, but I would place most of the focus on the content. The lawyers can be pretty good, and they can sometimes find a loophole. But usually, if the content is there, they're going to prevail in a court.
Okay, quickly, Google versus Apple. Who ends up, I guess, who ends up winning, if anybody, at the end of the day?
I'm not sure anybody's going to wind up winning this one. What the judge has said
the lawyers win.
The lawyers win, yes. But what the judge has said is both of you, both Google and Apple, are going to have a hard time proving that even if this patent was violated, one of you has been damaged. One of you has suffered something. And if you haven't suffered anything, it's like no harm, no foul. And so in the end, you can have infringement, but no damage, and the judge will simply make the whole thing go away.
All right, great job trying to explain something what lawyers do every day, I guess.
Yeah, complicated, long-standing.
All right, Karl.